Good morning, good afternoon, good evening to one and all present. Students, we in the previous class we have read about doctrine of ultra-vires. So in this class also, we will start with the fresh concept, doctrine of indoor management. But before that, I would like to give you a glance of what we have studied before. Yeah. So basically, in the previous class, we have read when the company, how the company law 2013 came into in effect, right? So history and development and concept, like joint stock companies act, it came. Joint stock companies act 1857, it came. After 1860, 66, 1913, 1936, 56 and 2013 finally. And there were important committees which were recommending the changes in the company law. We have studied in the previous class. That is Baba Committee, Sastri Committee, Sachar Committee, Chantrete Committee, Iradi Committee, Joshi Committee, and Naresh Chandra Committee, Irani Committee, Vires Committee and Company Law Committee. Basically, this Company Law Committee has given the enforcement of the Company Law 2013 and LLP Act 2008. Yeah. So, next is that we will read is like company law, how it is came into effect. Yeah. So company law stipulates, it is coupled with the following attributes, the important attributes. First was business friendly corporate regulation, protection of minority shareholders got after the company law enforcement, strict enforcement and audit accountability, enhanced accountability of management, enhanced disclosure norms were there, CSR, and better framework for insolvency regulation and in structured structure and corporate good governance. Yeah, this is how company law we have read. Now, very important concept that we have studied in the previous class was doctrine of ultra-vires. What is doctrine of ultra-vires? It is derived from the Latin words like ultra means what? Beyond, virus meaning power or authority. So ultra-vires means any act that lies beyond the authority of the company to perform is ultra-vires. It is void ab initio. So three concepts have come into force with ultra-vires doctrine. First was ultra-vires the Companies Act, ultra-vires the MOA, ultra-vires the AOA. Yeah. So ultra-vires the Companies Act means which is void, it is void ab initio, and it cannot be ratified. It cannot be means ratified. What is the meaning of ratification? It cannot be changed by unanimous resolution of all the shareholders. Second concept we have read in the previous class was ultra-vires the MOA. What is the MOA of the company, which was very important document of the company, which represents the founding stone of the structure of the company. Yeah. So here MOA usually covered object clause, capital clause, name clause, situation clause, where the company is basically situated. These all comes into an ultra-vires MOA of the company. These all clauses come under the MOA of the company. So such an act which is ultra-vires the MOA, it is void and cannot be ratified even by unanimous resolution of all the shareholders. Ultra-vires the AOA. Now what act is ultra-vires the AOA? Means if any act, these acts are also void, means ultra-vires the AOA, but the general meeting may alter the AOA by passing a special resolution and ratify the unauthorized act. So in this also, which is ultra-vires the AOA of the company, that acts can be ratified. This particular ultra-vires the AOA wala concept, it can be ratified by the shareholders in the general meeting. Next, there was some case law which we will finish it up in this lecture probably. So, in the previous class, we have read loans, borrowing, guarantees, and ultra vires rules. Implied powers. What are the implied powers? Powers which are not implied. This all we have read. And what were the effects of ultra vires? Void ab initio, injunction, personal liability of the directors, ultra vires tort, ultra vires grants, and what guarantees? Yeah. So there were four exceptions to doctrine of ultra vires. What were the four exceptions? First exception was any act which is done irregularly but otherwise it is intra vires the company can be validated by the shareholders of the company by giving the consent. It is not done regularly, it is done irregularly. Sometimes it is done, okay, but otherwise it is intra vires. It comes under the powers of the company, then it can be validated by the shareholders in general meeting. First point. Second point, if the act is deemed to be within the authority of the company. Now any act, suppose I am a director of a company, obviously I am a director of the company, I have to oversee what my management, what my my management level people are doing, so that is impliedly under my power, so it is within the authority also. So see, if any act which is deemed or impliedly to be in authority of the company by the Companies Act, then they will not be covered as the ultra vires even if it is not expressly stated in MOM. Any incidental or consequential effect means any effect of the ultra vires act will not be invalid unless what Companies Act prohibits it. जब तक until and unless Companies Act prohibits such particular act, it is not ultra vires the company, that effect of that act, right? Fourth point, any act which is outside the authority of the directors of the company but it is intra vires the company. Me as a director, I don't have the authority to borrow loans, but yeah, it is intra vires the company, I can borrow loans. Who are authorized? Directors are authorized to borrow loans, so it is intra vires the company, it can be ratified by the shareholder of the company. Four acts, again we will study fast. First of all, when an act is done irregularly but otherwise it is intra vires the company. Second, deemed to be within the authority of the company by the Companies Act, then it will not be considered as ultra vires even if it is not expressly stated. Any incidental or consequential effect will not be invalid unless company law prohibits it. Any act which is outside the authority of the directors of the company but otherwise it is intra vires the company, it can be rectified by the shareholder, right? These are four of the exceptions. Next is doctrine of indoor management. Doctrine of indoor management, there are basically two concepts in this. Firstly is doctrine of indoor management. Doctrine of ultra vires that we have already done. Now that concept is doctrine of indoor management. Yeah, you can write down. This is in favor of outsiders. Means who can invoke this? Outsiders. Doctrine of constructive notice means who can invoke this? Company. Just write down this. I hope you've written this. So, see, what is doctrine of indoor management? First, we will understand it normally, verbally first of all. Doctrine of indoor management means, if suppose I, being an outsider, I don't know, I have purchased or I have taken loan from your company. That particular loan which was taken from your company, I don't know, the directors need to pass a resolution in the company and get it approved by the shareholders of the company. Suppose I don't know this is your internal matter, this is your company's matter, I am not aware of this. Law cannot sue me, but I can sue the company. Why? Because I am nowhere. See, I am not here to inquire each and everything, your internal affairs of the company. I bought a loan, impliedly I know, yeah, directors had the power, I took a loan. But though directors didn't have power, I don't know how to, I have not inquired about this. So it will come into my favor. This is doctrine of indoor management. Second doctrine is doctrine of constructive notice. Suppose this will come in favor of company. Suppose company will say, yeah, though we have given you loan, but this is your responsibility to inquire that, yeah, sir, this particular company secretary, sir, or madam, do you know that your directors are authorized? I hope that your directors are authorized to lend me a loan. They have this power. I have not inquired. But if I have not inquired, it will come into your company's favor. Yeah, doctrine of constructive, this particular person should inquire before entering into transaction of the company. So both of the doctrines say, first for indoor management, it is in favor of the outsider. Doctrine of constructive notice in favor of the whom? Doctrine of indoor management is in favor of the outsider, and doctrine of constructive notice in favor of the company. So let us read. While the doctrine of constructive notice seeks to protect the company against the outsiders, the principle of indoor management operates to protect the outsiders against the company. So they are protected against the company in this particular doctrine. This doctrine emphasizes on the concept that an outsider whose actions are in good faith and has entered into transaction with a company can have a presumption that there are no irregularities internally and all procedural requirements have been complied by the company. So this particular doctrine, it emphasizes on the concept that an outsider whose actions are in good faith, me being an outsider, my actions are in good faith and there are no irregularities in my actions, then it will come into my favor. The doctrine of the indoor management, also known as Torquand rule, is around 150 years concept which protect outsiders against the actions of the done by the company. So doctrine of indoor management, it is also known as the Torquand rule. Okay. One important case law it is, we will read, write down Royal British Bank versus Torquand. So Royal British Bank versus Doctrine, this is very important case law. The directors of the banking company were authorized by the AOA to borrow on bonds such sums of money as to time by resolution by the company in general meeting, as authorized by the what to borrow. The directors gave a bond to Doctrine without the authority of such resolution. Now, in this particular company, this Union Bank, British Bank, sorry, Royal British Bank. In this particular company, this particular bank, the directors, they were authorized to give money to an outsider only by following a procedure. Only what was the procedure? To get what? To get a resolution passed in the company that yeah, you are authorized to give money, directors. Now they have given money to this particular person, Turquoise, without this authority. See what happened. It was held that Turquoise could sue the company. Sue the company means they can enforce a case on the company on the strength of the bond, as he was entitled to assume that the necessary resolution. He assumed that the necessary resolution was passed. Lord Hartley observed that outsiders are bound to know the external position of the company, but they're not bound to know the internal management. How the internal management works, how can an outsider know? He only knows how the outside things work, right? So, come to third paragraph directly. Object of this section is to protect the persons dealing with the company, outsiders as well as members, by providing that the acts of the person acting as a director will be treated as valid, although it may afterwards be discovered that his appointment was invalid or that it may terminated under the provision of the act or the AOA of the company. See, this concept, suppose if a director says, yeah, I thought at the time the transaction was made with you, I was vacated at time as per the AOA, but no, that person don't know who entered into transaction, don't know what date this director has. He is a director as per him. So this needs to be validated. This act needs to be be in favor of the outsider, right? So Ram Raghuveer Lal versus United Refineries was the second case law. You can just write it here. Ram Raghuveer Lal versus United Refineries. So these two case laws, if suppose this concept come into your examinations, firstly explain what is indoor management, secondly write down these two case laws. Yeah. Now we will start with doctrine, one example of indoor management. This fact can come into your examination also. Question was, Planet Limited received a check from Earth Limited. So Planet Limited, one company, received a check from Earth Limited. AOA of the Earth Limited provided that checks issued by the company need to be signed by two directors and countersigned by the secretary. The directors nor the secretary who signed the check was appointed properly, and this the check issued was not valid. Planet Limited sued the company for the irregularities in the procedure. Is it liable for relief? Planet Limited is entitled to relief, and the company has to pay the amount of the check since the appointment of director is a part of the internal management. See that appointment was invalid, appointment was not done as per the company law. That is just the internal management wala procedure. It is not the duty of an outsider to see that yeah, your director was properly appointed or not, right? And a person dealing with the company is not inquirer about it. This is how it will run. Yeah. So doctrine directors, come directly to this paragraph. Directors not aware of their disqualification. See, the allotment and forfeiture of shares by the directors who continue to act even after they are disqualified, but they are not aware of it, was saved by section 176. See, if suppose I been a director, I have entered into an allotment of shares transaction, but I am not aware that I am disqualified by the act, so I will get a shield from the company law. Then, where this section does not save the situation, the company may in general meeting ratify the allotment of share even if it is made by de facto directors with malified intentions. Where the director in questions were not aware of the fact that by virtue of certain provision in the articles, they had vacated their office, their acts in passing the resolutions for starting certain business transactions were held to be valid. So, see, when it is done in good faith, directors don't know their position exactly, then they can get a shield. It is important to remember that the doctrine of constructive notice can be invoked by the company. Now comes constructive notice. Indoor management can be invoked by the outsiders. Now comes constructive notice. This doctrine can be invoked by the company. And it does not operate against the company. It operates against the person who failed to inquire but does not operate in his favor. But the doctrine of indoor management can be invoked by the person dealing with the company and cannot be invoked by the company. An outsider is entitled to act by on a certified copy of the resolution of the BOD delegating the powers of the borrowing money to the managing director subject to the limitation. See, suppose I am having the certified true copy of the resolution, whereby any director is authorized to sign the resolution of lending money or borrowing money, then it is a valid proof for me being an outsider. Now, what can be the exceptions to the indoor management? How this cannot be invoked? I mean, how it cannot be in favor of an outsider? The above noted doctrine of indoor management is, however, subject to certain exceptions. In other words, relief on ground of indoor management cannot be claimed by an outsider dealing with the company in the following circumstances. So, first circumstances, where the outsider had knowledge of irregularity, where he know this irregular situation, this situation is not in a normal context, normal business of the company. The rule does not protect any person who has actual or even has implied notice of the lack of authority of the person acting on behalf of the company. So, the rule does not protect any person who has actual notice, who has notice, that person does not have the authority to act on behalf of the company. Thus, the person knowing fully well the director does not have the authority to make any transaction but still enters, it cannot seek the protection of the law of indoor management. This case law, Howard versus Patent Ivory Company. Just highlight this case law in the book only. So, the articles of the company empowered the directors to borrow up to £1,000 only. This is the facts. What happened? The articles of the company empowered the directors to borrow up to 1,000 only. They could, however, exceed the limit of 1,000 with the consent of the company in general meeting. Without such contents having been, they borrowed £3,500 from one of the directors who took debentures. The company refused to pay the amount, held that debentures were good to extent of £1,000 only because directors had notice or nor deemed to have the notice of the internal regularity. Clear? So this they just have powers to give this particular pounds, 1,000 pounds, but this transaction was 3,500. So this case means the company refused to pay the amount, held that the debentures were good to the extent of 1,000 pounds only. He should have inquired. Who? Outsider. First, outsider had knowledge of irregularity. He had knowledge. He has impliedly noticed that yes, this person lacks the authority to enter into particular transaction with me. No knowledge of MOA and AOA. He do not have any knowledge. Again, the rule cannot be invoked in favor of the person who did not consult the MOA and AOA of the company and thus did not rely on them. So, for this particular, I being an outsider should ask for MOA and AOA. Give me your MOA or AOA. Are you authorized by your MOA and AOA of the company, right? In Rama Corporation Proved Retain versus General Investment Company, T was a director in the company. He, purporting to act on behalf of the company, entered into contract with Rama Corporation and took a check from the later. Now he took a check. The AOA did not provide did provide that the directors could delegate their powers to one of them. But Rama Corporation people had never read the articles. Later it was found that the directors of the company did not delegate the powers to T. They cannot delegate the powers to. The plaintiff relied on the rule of indoor management, held they could not, because even did not know that power could be delegated. So what happened? This particular T was the director of the company. He purporting to act on behalf of the company. He did not have any power to act in such transaction as per the internal document of the company, that is AOA. So this person who is Rama, so this company Rama Corporation should have inquired this company's documents before entering into this transaction. So no knowledge of MO and AOA is an exception to indoor management. Forgery, theft. Okay. Now forgery. See, we will write down. I will change the pen exceptions. Second point was no knowledge of MOA and AOA. First was had knowledge of irregularities. Next is forgery. The rule of indoor management does not extend to the transaction involving forgery or to transactions which are otherwise void or void ab initio. It is void ab initio, then you cannot claim, you cannot invoke indoor management. It is not that there is absence of free consent, but there is no consent at all. The person whose signatures have been forged and is not is not even aware of the transaction, and the question of his consent being free or otherwise does not arise. Consequently, it is not that the title of the person is, but it is not title at all. Therefore, howsoever clever the forgery might have been, the personage acquires no title at all. Thus, where the secretary of the company forged signature of two directors required under AOA on the share certificate and issues certificate without the authority, the applicants were refused registration as members of the company. These certificate would held in nullity, and the holder of the certificate was not allowed to take advantage of the doctrine of indoor management. Why? Because this particular transaction whereby this certificates needs to be signed by two directors, and the company secretary being an important KMP of the company, it made a duplicate signatures and issued to the applicant. So this doctrine of indoor management cannot come into invocation. Forgery in case of the company can take place in different forms. It may, besides forgery of the signatures of the authorized officials, include the execution of the documents towards the personal discharge of an official liability instead of liability of the company. There is a bill of exchange signed by the manager of the company with his own signature under words stating that he signed him on behalf of the company was held to be forgery when the bill was drawn in favor of the payee to whom the manager was personally indebted. The bill in this case was held to be forged because it is purported to be a different document for what it was. In fact, it is purported to be issued on behalf of the company in payment of the debt when in fact it was issued in payment of the manager's own debt. Suppose a manager of the company, he himself a check needs to be, he has a personal debt whereby in that check is written, yes, this check is so and so made on behalf of the company, means this he made a signature and written one line that on behalf of the company this payment will be made. This act is also a forgery and it cannot be invoked. Next comes negligence. The doctrine of indoor management in no way revolves, let us write here also, negligence. So doctrine of indoor management in no way rewards those who have negligently Thus, where the officer of the company does something which shall not ordinarily be within his powers, the person dealing with him must make proper inquiry and satisfy as to officer's authority. If he fails to make an inquiry, he is stopped from relying the rule. In case, in this Underwood versus Benpoff Liverpool, a person was a sole director and principal shareholder of the company, deposited into his own account checks drawn in favor of the company, held that the bank should have made inquiry as to the power of the director. Bank was put under the query and was accordingly not entitled to rely upon the ostensible authority of director. So they would have made an inquiry that this particular director has authority or not. Similarly, in case of Anand Baharilal versus Jinshaw and Company, an accountant of the company transferred some property of the company in favor of Anand Bihari. On an action brought by him on the breach of the contract, the court held the transfer would be void. It was observed that the power of transferring movable property of the company could not be considered within the apparent authority of the accountant. Means he cannot transfer the property in his own name on behalf of the company. Again, the doctrine of indoor management does not apply where the question is in regard to the very existence of the agency. ठीक है. In Bakery Saubre versus Karelia Banking Company Limited, the Honorable Kerala High Court held that the doctrine of indoor bench cannot apply where the question is not as to the scope of the power exercised by the apparent agent of the company, but with regard to the existence of the agency. The doctrine is not applicable where a precondition is required to be fulfilled before company itself can exercise a particular power. In other words, that done is not merely ultra-vires the director's officers but ultra-vires the company itself. Means it is not applicable where the precondition is required to be fulfilled before company itself can exercise a particular power. Means the particular act is not merely ultra-vires the directors, it ultra-vires the company also. In the end, it is worthwhile to mention section 6 gives overriding force and effect the provisions not for anything to contradict any MOA of the company or an agreement executed by the company in general meeting. A provision contained in the MOA, AOA, article, resolution, which is repugnant to the provision of the, it is regarded as void. Okay. So you can just highlight these points. Where the outsider had knowledge, forgery, then no knowledge of MOA and AOA, then negligence, then does not apply where the question is in regard to very existence of the you can just write down this point. Yeah. So, a corporation, organization, or entity set up to provide a legal sheet for the person actually controlling the corporation. So, question is, Butterfly Limited receives a share certificate of Flower Limited issued under the seal of the company. The company secretary issued the certificate affixing the seal and forging the signature of the two directors. Butterfly Limited files a lawful suit claiming that the forging of the signatures is a part of the internal management of the company. Is the claim of Butterfly Limited valid and is liable to get relief? According to the exceptions of the doctrine of indoor management that we have read before, no transaction involving forgery is null and void. So you cannot claim a shield on this. Since the document issued by Butterfly Limited is void and the claim made by him is not valid, thus he is not entitled to relief. Forgery case. Clear? Next come doctrine of constructive notice. In company law, the doctrine of constructive notice is doctrine where all the person dealing with the company are deemed to have knowledge of the company's AOA and MOA. Yeah, mark this. MOA and the AOA, when registered, become the public documents and can be inspected by whom? By anyone on payment of the nominal fee. Therefore, every person who contemplates entering into a contract with a company as a means of asserting and consequently presumed to know not only exact the powers of the company but also the extent to which the powers have been delegated to the directors and the limitations placed on the excess of the powers. In other words, every person dealing with a company is deemed to have a constructive notice of the contents of the MOA and the AOA. Means whoever is entering into a transaction, he should know the contents of the MOA and AOA. In fact, he is regarded not only having read those documents but also having understood them according to the proper meaning, right? Consequently, if a person enters into a contract which is beyond the powers of the company as defined in the MOA or outside the limits set on the authority of the directors, he cannot as a general rule acquire any rights under the contract against the company. So, for example, if the articles provide that a bill of exchange to the effective must be signed by two directors, or the person dealing with the company must see that it is so signed, otherwise he cannot claim, because that person is entering into a transaction, he should impliedly know the contents of the MOA and the AOA, which are the public documents of the company, and the public documents are available in the website of the MCA, which is also can be inspected by any person paying a nominal fee. A common example of constructive notice is when a court is unable to directly reach someone and publishes summons in public newspapers and it is assumed that everybody has read it. Means if in a particular newspaper, means a financial express newspaper, for example, English newspaper, and advertisement is given regarding a company. Obviously, it's a public document, everyone knows, everyone has read it, it's impliedly a power. In another case, the articles required that all the documents should be signed by the managing director, secretary, and the working director on behalf of the company. A deed of mortgage was executed by secretary and working director only, and the court had no claim to lie on such deed. The court said that the mortgagee should have consulted the AOA before the deed was executed. Therefore, even though the mortgagee may have acted in good faith and the money borrowed applied for the purpose of the mortgagee have nevertheless invalid, right? The doctrine of indoor management protects third parties who are entitled to win insurance, insurance that all the procedure aspects of the transaction are carried out. Outsider dealing with incorporated bodies are bound to take notice of the limit imposed on the corporation of MOA and other documents, right? Nevertheless, they are entitled to assume the directors or the other person accessing authority on behalf of the company are doing so in accordance with internal regulations set in MOA and AOA. But you know that me being an outsider, I know that I am entering into a particular transaction with a company. Definitely, this company and directors have the power. This is impliedly right. But being an outsider, being a layman, I should have read the MO and AOA before entering into transaction to make my own self very much aware, right? The impact of this doctrine on practical relation is thus stated in Halsbury. A company is entitled subject to the rule that where the conduct of the party charged with the notice shows that he had suspicious of the facts of the case, the knowledge of which would affect his legal rights, but that he deliberately refrained from, making the inquiries he will be treated had notice is not entitled to claim. Means I would have inquired about the main public documents of the company before entering any such transactions. Me being a layman should have done so, but I have not done so. It is this doctrine will not be in my favor. Next come doctrine of alter ego. The term alter ego is a Latin word literally translated into other I. More idiomatic, it can be understood as identical copy or the person's clone. It is common tenet that a company is a separate legal entity from its shareholder directors. This common law principle grants immunity to the shareholders and the directors from being held liable for the debts and criminal liabilities of corporation. Doctrine of alter ego, however, provides an exception to this presumption in law. Alter ego is a doctrine which prevents the stakeholders of the corporation, that is the shareholders and directors, from taking the refuge of separate legal entity. Means now come doctrine. These are the exceptions you have written, right? So fourth doctrine you can write down. This is in favor of so now this is in favor of your directors and your shareholders, that company being a personal like a separate legal entity, no person can sue director of the shareholders that why this transaction has been entered on behalf of the company and directors were not aware. They can take a shield of this doctrine that yeah, we being a separate legal entity, we are not personally liable for the liabilities of the company. Hence, doctrine of ultra vires is based on lifting the corporate wheel between the directors and shareholders and a cooperation, treating them both as one entity. Doctrine of alter ego is based on assumption that company as well as shareholders and the manager are the alter egos of each other, that is one of the shadow or reflection of the other, or can be understood as the two sides of the same coin. Hence, the courts can learn on alter ego where they find that there have been very thin line between distinction between directors and shareholders and cooperation or the limited liability. It is used by the courts to note the status of the shareholders' officers and doctrine in reference to their liabilities in their respective capacities, so that they are able to be personally liable for their actions when they have acted fraudulently and unjustly. See, when their actions have been fraudulently or unjustifiedly they have entered into transaction, then the court can rely on this doctrine saying that yeah, your personal liabilities can also be held liable. Why? Because the actions were treated fraudulently. Only if not forgery act. In case of forgery or So in case of forgery or fraudulent act, then this doctrine can be used. So Lennard's Carrying Company Limited was an Asiatic Petroleum Company Limited, propounded the alter ego theory and distinguished it from the vicious liability. The House of Lords stated that the default of the managing director, who is directing mind and will of the company, would be attributed to him, and he will be held wrongdoing of the company. Yes. One case law is there, very important case law, mark down, important. Sunil Bharti Mittal versus Central Bureau of Investigation clarified the law of alter ego. In this instant case, a special judge has summoned and proceeded against the directors of the company. The special judge had led, on the other hand, the reason for summoning this person proceeding against them are specifically ascribed in this para with prima facie are these persons who are in control of the affairs of the respective. Because of their controlling, they are representing the direct mind and will of the company. State of mind of these persons is the state of mind of the company. So they are described as alter ego of the respective company. So they are the important pillars of the company, we can say. So these can be what they can be held liable for their acts. The apex court, while overruling the decision of special judge, observed that the special judge had applied the rule of alter ego. It had done so in reverse. The criminal means rea had been attributed to the directors on the assumption they are the directing minds behind the powers of the company. Supreme Court observed that the special judge had ignored the fact that such an interpretation of the alter ego doctrine would go against the position of law, as there was no vicious liability in criminal law unless expressly provided in the statute. This is not simple. You will write down 3 points. Okay. Don't write the overruling thing. Next is doctrine of lifting or pressing the corporate will. So now we will read this. The separate personality of the company is a statutory privilege and it must be used for legitimate business purposes only. Where the fraudulent and dishonest use is made of the legal entity, the individual concerned will not be allowed to take shelter behind the corporate personality. The court will break through the corporate shell and apply the principal doctrine of what is called lifting or pressing the corporate wheel. The court will look behind the corporate entity and take actions as though no entity separate from the members existed, and make the members of the controlling person liable for the debt and the obligation. See, what is it? Means the separate personality, separate legal entity. We understand that a company is a separate legal entity from the directors and from the persons who has formed them. But the purpose of the company should only be used for the legitimate use, not other than the legitimate. Illegitimate use and fraudulent uses should not be used. So if it is used in the company, the court can use this doctrine of lifting or pressing the corporate wheel. Statutory recognition. The corporate will is in the defense proceedings such as evasion of tax, and it relies on its personal corporate personality as a shield to cover its wrong deals. This is Janardhan Mohandas Rajan Pillai. This is not important case law, but you can give an example. You can just write it down. Okay. However, the shareholder cannot ask for lifting the wheel for their purposes. For their own purposes, they cannot. This was held in Premlata Bhatia Union versus Union of India. wherein the premises of the shop was allotted on a license to an individual licensee. She set up a wholly owned private company and transferred the premises to that company without the government consent. She could not remove the illegitimacy by saying that she and her company were virtually the same person. Yeah. Statutory recognition of lifting the corporate wheel. The Company Act itself contains some provisions which lift the corporate wheel to reach the real forces of the action. Section 7, subsection 7 deals with the punishment for incorporation of the company by furnishing the false information. 251 deals with liability for making the fraudulent application for removal of name. From 339 deals with liability for fraudulent conduct of business during the course of winding up. So 339 also deal with liability for fraudulent conduct of business during the course of winding. This is relating to winding up. This is relating to fraudulent application for removal of name, and this is relating to punishment for incorporation by furnishing the false information. So these three sections also deal with corporate of statutory recognition of lifting the corporate wheel. Lifting the corporate wheel under judicial interpretation. Ever since the decision in Salmon versus Salmon and Company Act, normally courts are reluctant or at least very cautious to lift the wheel of the corporate personality to see the real persons behind it. Nevertheless, courts have found it necessary to disregard the personal liability of the company in the following situation. What was it? Where the corporate wheel has been used for commission of fraud or improper conduct. In such situation, the court has lifted the wheel and looked the realities. Suppose if there is a fraud or improper conduct, then the corporate wheel can be lifted. Yeah. Then where the corporate facility is the rarely one only an agency, rarely only an agency instrumentality, then it is this. See, and supposedly an American company produced a film in India, technically in the name of British company, 90% of whose capital was held by President of American company, which financed the production of the film. Board of the Trade refused to register the film as a British film, which stated that English company acted merely as nominee. So, where there is an agency instrumentality, then also it can be. So, you can just mark this case law, RG Films Limited. Then is not important. Where the conduct conflict with public policy, courts lifted the corporate wheel for protecting the public policy. In Connors Bros versus Connors, the principle was applied against the managing director who made use of his position contrary to public policy. In this case, the House of Lords determined that character of the company as enemy company, since the persons who were de facto in control of its affair were resident of Germany, which was at war with England at that time. Means this transaction which was made, they were made by residents of Germany, which was in war with England at that time. The alien company was not allowed to proceed with the action, as it would be meant giving money to the enemy, which was considered as monstrous and against the public policy. So here, against the public policy is also a what? It can be lifted. Doctrine of corporate wheel. Fourth is, in Dalmar Company versus Continental Tire and Rubber Company, it was held that a company will be regarded as having enemy character if the persons having de facto control of its affair are resident in enemy country, or whenever they may be, they are acting instructions from on behalf of the enemy. This also situation. E. It was found that the sole purpose for which the company was formed was to evade the taxes. This was the only reason that the company was formed. The court will ignore the concept of separate legal and make individual concerned liable to pay the taxes if they would have paid for the formation of the company. This is also an important case law. Which one? This one. Sir Dingshaw. This. The facts of the case, we will read it. Normally we will read it, we will try to understand it. You can change the language of the case law. When you have understood, you can change the language, but it's very important whenever you are justifying your answer, right? Always make a practice to write a case law also. Sir Dingshaw Manekji, the facts of the case are that the SSC was a wealthy man enjoying large dividend and interest income. He formed 4 private companies and agreed with each to hold a block of investment as an agent for it. Income received was credited in the accounts of the company, but the company handed back the amount to him as a prudent loan. This way, he divided his income in 4 parts, right, in a bid to reduce the tax liability. He formed 4 companies. This was the only reason, like, he divided his income in such a way that the tax liability got reduced. In this case, the court can uplift the corporate weal. But it was held that the company was formed by the SEC purely and simply as a means of avoiding super tax, and the company was nothing more than a SEC himself. It did no business, there was no business in this company, but was created simply as a legal entity to obstinately receive the dividends and interest and to hand them over to SEC as prudent loans. The court decided to disregard the corporate entity as it was used for tax evasion. Clear, Sir Dingshaw? Next is the Vodafone case, which is very important case. There are some case law on this concept, right? And it is very important. That's why I'm making you read all. But at the end of the class, I will tell you which all case law you have to, pakka you have to do. By sure you have to do. Vodafone case, one of the landmark case of the Supreme Court. This is also important, please. In its decision in the case of Vodafone International Holdings, BV versus Union of India and another, in the judgment, the Supreme Court set aside the Bombay High Court judgment directing Vodafone International Holdings BV to pay 110 billion as withholding tax in a transaction that took offshore. This you can just read it in your next chapter, in your next class. I will give you a summary of this case, but before that I would want you to read a full case law. I will give you summary wise, okay? Then avoidance of welfare legislation as a common advantage as avoidance of taxation and approach in considering problems of such avoidance as necessarily being same. Therefore, we have found the sole purpose of formation of a new company was that to use it as advice to reduce the amount to be paid by way of bonus to workmen. Supreme Court upheld the passing the corporate bill to a real transaction. Case law was workmen employed in Associated Rubber Industries, Bhavnagar. So next was the workmen employed in Associated Rubber Industries Limited, Bhavnagar versus Associated Rubber Industries, Bhavnagar and another. The facts of the case were that a new company was created wholly by the principal company with no assets of its own except those transferred by its principal company, right? Which with no business or income of its own except receiving the dividends. Only receive the dividends for the shares transferred by the principal company. It is only for the purpose of splitting the profits into two hands and thereby reducing the obligation to pay the bonus. The Supreme Court of India that a new company was formed as a device to reduce the gross profit of the principal company and thereby reduce the amount to be paid by way of bonus to the workmen. The amounts of the dividend received by a new bonus should therefore be taken into account when assessing the gross profits of the principal company. So this new company was formed only to reduce, ignore the payment of to the workman. Another instance of corporate wheel arrived at a case law in Kapila versus state of Bihar. In this case, the petitioner alleged that the state of Bihar had not paid salary to the employees in PSUs for a long period, resulting in starvation deaths. But the respondent took the stand that most of the undertakings were incorporated in the provisions of 1956. Hence, the rights etc. of the shareholders should be governed by the provision of the Companies Act, and liability of it should not be passed to the state government by resorting to the doctrine of lifting the corporate wheel. The court observed that the state may not be liable in relation to the day-to-day functioning of PSU, but its liability would arise on its failure to perform the constitutional duties and the function of this undertaking. It is so because life means something more than the ordinal existence. The inhibition against deprivation of its life extends to all those limits and faculties by which. So this is also the case law where, like, the PSUs, they were the workers in the PSUs, they were not getting the pay. Why? Because the court held it is governed by the Companies Act. It is the state to pay this. But now this was not the case, and it was this principle was applied. Now when it is in the fact of the case is, yeah, this deprivation of life comes, then obviously Do not bifurcate or divide your powers. Where it is found that the company has abused its corporate personality for the unjust and inequitable purpose, the court would not hesitate to lift the corporate wheel. Further, the corporate wheel could be lifted when acts of the corporation are allegedly opposed to justice, conveyance and interest of revenue or workmen, or are against the public interest. Thus, in appropriate cases, the courts may disregard the separate corporate personality and look behind the legal person or lift the corporate wheel. Fine. So these are some of the points that in what all cases the corporate wheel can be opened. Lifting the corporate wheel of small scale industry. So please write down first of all important case laws. You have to go through them properly. Justify your answers with this case law. Four case laws are sufficient. First one, RG Films Limited, 30%, 90% of whose capital was held by President of India, right? Nominee of American Corporation. So, this is important. Connors Bros versus Connors. England wala enemy case, okay. Delmer Company versus Continental Tire. Then it is Sir Dingshaw. I am telling you can do your own language also. You can write your own language also. Only thing is required is you should know what was happened in this case. Okay. Then Workman Employed, Associated Rubber Industries versus Bhavnagar. Associated Rubber Industries Bhavnagar versus Associated Rubber. No, Workman Employed in Associated Rubber Industries Limited Bhavnagar versus Associated Rubber Industries Limited Bhavnagar. Means workman and company. Workman and company. This is workman. They have made a case against the company only. Okay. Workman and Associated Rubber Industries versus Associated Rubber Industries. Okay. Now, lifting the corporate wheel of small scale industry. Before that, I want you to just write this important case law and highlight it. Highlight in your notes. Important case law for doctrine of lifting corporate wheel. Okay, lifting the corporate wheel of small scale industry, where small scale industries were given separate exemptions and the company owning an industry was controlled by small group of persons or company. It was held that it was permissible to lift the wheel of the company to see whether it was a subsidiary of another company and therefore not entitled to the proposed exemptions. Right, this is just a simple case law. Use a corporate wheel for hiding the criminal activities where the defendant used the corporate structure as a device or facade his criminal activities, evasion of customs and excise duties payable by the company. The court could lift the corporate wheel and treat the assets of the company as a realizable property of the shareholder. For example, in the case, it was prima facie case the defendants controlled the two companies and companies had been used for fraudulent evasion of excise duty on large scale. The defendant regarded the companies as carrying as on a family business and that they had benefited from companies cash in substantial amount and therefore no useful purpose would have been served by involving the companies in criminal proceeding. All these circumstances, it was therefore appropriate to lift the corporate wheel and treat the stock in the company's warehouses and company's motor vehicles or realizable property held by the defendant. The court said that the excise department is not criticized or not charging the companies. The more complex commercial activities became more vital. It is for prosecuting authorities to be selective in whom and in what charge so that the issues can be presented in as a clear and short form as possible. In the present case, it was seemed that no useful purpose would have been served by initiating criminal proceedings. So, this can be, for criminal activities also this doctrine can be changed. So, applicability of Companies Act, new concept, this is just for your knowledge only. So, for which all companies, it is not applicable to unincorporated company. It should be proper cooperated company following the proper incorporation of the company as per the Company Law Act. So then only it is useful. Okay, then interpretation of definitions of Companies Act. A definition is what? Definition is the statement of the meaning of the word or the phrase, right? Usually every statute has a definition sections. It is called interpretation clause, which provides definitions of various words and phrases used in the statute. Definition is to define the act of making something definite, clear. Definition and exact statement or description of the nature. In relation to statute, definition given in the statute are those of certain words or expression used elsewhere in the statute. Object of using definitions to avoid frequent repetition. The definitions are what? Used to aid interpretation of words for that specific statute. So, types of definitions are there. One is restrictive and second is extensive. Restrictive, it is use the word mean, and extensive means use the word include, means particular word it includes, and one particular word is used, it means, right? When in a definition the word mean is used, it means word is restricted to the scope indicated in the definition section. It means definition is hard and fast definition and no other meaning can be assigned to the expression. So yeah, so definitions, types of definitions, just a second, bear with me. So types of definitions are there. First is the restrictive and then second is the extensive. Where in the definition the word mean, okay, where in the definition of word mean, it is used means word is restricted to the scope indicated in the definition section. It means definition is hard and fast definition and no other meaning can be assigned to the expression. Then it is Puch definition. Director means the director appointed to the board of directors. The word include gives a wider meaning. I tell you na, include may everything will be included, right? So, meaning to the words or the phrases in the statute. This legislature does not intend to restrict the definition. It makes the definition and numerative than extensive. This is to say the term defined will retain its ordinary meaning, may or may not compromise. The word includes by the legislature shows the intention of the legislature that is wanted to give extensive and enlarged meaning to such expression. Means includes large and extensive meaning. For example, body corporate or cooperation includes a company incorporated outside India but does not include a cooperative society registered by any law leading to cooperative society. Any other body corporate. So, this example did. Explanation in statutes is a very important, means explanations to explain, to clarify the meaning of words which forms the part and parcel, does not widen the scope of word explained. Some of the important definitions and key concepts are there in Companies Act. You will read company, company limited by shares, company limited by guarantee, holding company, public company, subsidiary company, private company, one-person company, small company, dormant company, nidhi company, listed company, government company, foreign companies. One by one we have to read all these definitions, are very important. Important, and it can come into your exams for 2 marks. Focus on this, please. First of all, company means what? Company means company incorporated under this act or under previous company law. Previous company law, we have read a proper emergence of this company act 2013. So any company which is incorporated in 1956, that also definition is covered. 2013, that also. Clause 20 subsection clause 21, company limited by guarantee, means a company having the liability of its member limited by the MOA to such amount as the members may respectively undertake to contribute to the assets in the event of its winding up. Guarantee means, if suppose I am a company limited by guarantee, so at the time of winding up, me being a member of a company, I have to contribute to such amount which is limited by the MOA. Company limited by share means a company having liability of its member limited by the MOA to the amount, if any, unpaid on the shares respectively. Means if any amount which is unpaid on the shares, in that case I am company limited by shares company. Holding company to subsection 46 in relation to one or more company means a company of which such company is a subsidiary company. So this example, I will write on here only. Holding company, suppose this is a holding company which are having many subsidiaries. So this will be subsidiaries company. This will be the parent company. So company includes any body corporate. Public company means a company to subsection 71, sorry, clause 71. Two clause, two is going on clause, sub clause, okay, which is not a private company, has a minimum paid up share capital as may be provided. Provided that a company which is subsidiary of a company not being a private company shall be deemed to be public company for the purpose of this act, even when the subsidiary company constitutes to be private company in its article. Then clause 87, subsidiary company in relation to any other company, that is to say the holding company, means a company in which the holding company, this holding company, it is holding what composition of BOD, exercises or control more than half of its voting rights either on its own or together of its subsidiary. Provided that such class or class of the holding companies may be prescribed shall not have layers of subsidiary beyond such numbers as may be prescribed. Means this class or class of the holding company should not go beyond what is prescribed, that layers of the subsidiary company. You can have maximum subsidiary companies which is prescribed under the Companies Act. Explanation: for the purpose of this clause, a company shall be deemed to be subsidiary company of its holding company even if the control the subsidiary company of the holding company, the composition of the BOD shall be deemed to be controlled by another, right? So one person company introduce a new type of entity to the existing list, that is 2 subsection 62. Apart from forming a public or private, the act enables the formation of one person company. Company with only one person as a member is a one person company. 2 subsection 68, private company having a minimum paid up share capital may be prescribed and which by its article restrict the right to transfer its share except in case of one person, limits the number of members to 200. Provided that whether 2 or more persons held more than one shares in a company jointly, then they shall for the purpose of the case shall be treated as a single member. Suppose if single member holds 2 shares in his name, he will be treated as one person only. Provided further the person who are in employment of the company, persons who have been formerly in employment were members of the company, while in that employment have continued to be members after their company shall not be including a number. Means who are in employment of the company is 200, in this 200 persons who are in employment and who have been formerly in employment were the members while in that employment and they continue to be the members after the employment cease, then they will not be counted. In these 2 persons, people will not be counted, okay. Prohibits any invitation to public to subscribe to the securities of the company. Small company, rule 2, sub rule 1, clause T of the company, specification of definitions, detailed rules with effect from September 15, 2022. This is very recent, so you please underline this. Clause 85 has amended the definition of small company 2 subsection 85 of the Act. Paid up and turnover of small company shall not exceed 400 and rupees 50 crore respectively. So this turnover should not exceed 400 and paid up share capital should not exceed 400 and turnover of the small company should not exceed what? 40 crore, right? So there's a small company of this with effect is here. Small company is defined rather than the person. Paid up share capital of the company does not exceed 400 crore. Such other amount as may be prescribed which should not be more than 10 crore. Turnover as per P&L immediately preceding financial does not exceed 440 and such other amount may be prescribed should not exceed 100 crore. Clear? Nothing in this clause shall apply to holding subsidiary company registered under section 8, non-profit company and the body corporate governed by special act. Next is dormant company which is formed and registered under section 213 for what? For a future project or to hold an asset or intellectual property and has no significant accounting transaction. Such a company is inactive, may apply to register for recognized status of dormant company. For some intellectual property or some future project के लिए that company is formed, that is a dormant company. Nidhi company means a company which is cooperated as a nidhi with a project of cultivating the habit of thrift and savings from among the members, receive deposits and lending. Means we are receiving the deposits and you are lending to the members only for their mutual benefit and which complies with such rule as may be prescribed. Means for only for members. Write down. Then comes listed company, means a company which has its security listed on any recognized stock exchange, provided its class will have listed or intend to list specific authorities may be prescribed under SEBI, shall not be considered as a listed company. When in consultation of SEBI you are getting listed, then you are not a listed company. Companies not to be considered listed companies. The following class of companies shall not be considered listed company, namely public company which have not been listed their stock equity shares on stock exchange but have listed their debentures, debt, redeemable preference shares, then you are not a listed company. Private company which have listed their non-convertible debt on private placement. Public company which have not listed their equity share on recognized but whose equity share listed on a stock exchange in a jurisdiction as specified, right? So in this case you are not a listed company. Next comes the foreign company and the government company. What is government company? To subsection 45, company which in which not less than 50% of the paid up share capital is held by central government or any state government or partly by central government, partly by one state or the state government, and includes a company which is subsidiary company of such government company. Clause 42, foreign company means a company or body incorporated outside India which has place of business in India, whether by itself or through agent physically or electronically, conducts any business activity in India. So first is having place in India, okay, whether itself or through agent they are conducting their what business. Second is conduct its business activity in India in any other manner. Role and responsibilities of the companies under Companies Act. What are see, officer, who is officer as per Companies Act? Maybe director, manager, KMP of the company. In whose direction and instruction the BOD or any one of the directors are companies to act. Who is KMP? CEO, company secretary, whole-time directory, CFO, such other officer not level below the directors is whole-time employment designated KMP, such other officers. The role and have no defined in various. Promoter, who is promoter? Who has been named in the prospectus or identified by the company's annual report, who has control over the affairs of the company, who is in accordance with whose advice the board of the company is to act. Next is, but it shall not apply to a person who is acting merely in a professional capacity. Suppose I am just giving you a professional advice, being a consultant, then I am not a promoter of the company. Independent director, it is defined in the act along with several new requirements relating to appointment, role and responsibility. Independent director means a independent director the term independent director means independent director referred in the subsection 6 of 149 Act. Auditor and auditors, mandatory auditor rotation and joint auditor, mandates rotation of auditor after specified time period, secretarial auditor, mandatory secretary for the following: listed company, every public company having paid up share capital of 50 crore, public company having turnover, every company having outside loans or bank or financial for 100 crore, right? So these should have the secretarial auditor. It is required to be next to the board's report, right? Then is secretarial standards. The act requires every company to observe secretarial standards specified by the Institute of Company Secretary with respect to general and board meetings, right? Class action suits, new concept, class action suits which can be initiated by shareholder against the company and the auditor. So shareholders, they can initiate against the company. These are important definitions. You can just give it a glance. No need to just cram this, and you can just go ahead then. Yeah. So next comes simply this MCA 21 has come. This is just for your knowledge only. We'll just give it a glance and then we'll wind up this chapter then. E-governance and MCA 21. Next first I will important case laws I will start with, and then we can start with the second chapter, right? So this MCA 21 is a new version of the Company Act. This is in response for e-governance. and for operating simple, moral, accountable, responsive and transparent governance, this was formed. E-governance is highly complex process requiring what? Hardware, software, networking, re-engineering of procedures, right? Earlier, professionals and businessmen, they had to visit to MCA offices to file the forms. Now you can do it online, you also know. So MCA 21 is an ambitious e-governance initiative of government. It builds the government's vision of national e-governance in the country. As a part of the government's focuses on governance norms to meet the expectation rising from globalization, MCA project was launched with a flagship initiative under MCA. It has resulted in improved procedure for better delivery of services by MCA. This reform of administration has not only improved efficiency and transparency in the government operations, but has also enabled ministry to concentrate more on policy matters. The portal is defined to fully automate all the processes leading to enforcement and compliance of the legal requirements in the Companies Act, LLP and other allied and rules and framed thereby. So with this, everything has been clear. MCA 21 is a part of the mission road projects of all the government of India, bagging several accolades in the past. The project has now reached third version. Okay, it is a technology driven forward looking project, evasion for strengthen enforcement, promote ease of doing business and enhance user. MC 21 ruled out a plan and phases to ensure minimum disruption in regulatory filings. LLP files were upgraded and migrated to MCB3. 9 forms CAG 1, 4, 6, 8, 9, DIR3, KYC Web, DPT4 are available live from 1st September. Remaining company forms are programmed under 2 lots, 191 and 23. Means these all forms which are important statutory forms, now they have to operate from September 1st in MCA 3 version 3. First phase of MCA 310 comprising of revamped website, new email services for MCA officers and 2 new modules, namely ebook and e-consultation was launched during launch. Agencies under MCA 1. Who are the agency? Ministry of Corporate Affairs, Registrar of Companies, Director, Official Liquidator, Serious Fraud Investigation and NAFRA, that is National Financial Reporting Authority, National NCLT and National Company Law Tribunal, right? So you can just write down one line, make this chart. In your notes, make this chart: MCA, ROC, RD, OL, SFO and NAFRA, NCLT, NCLT. So ROC means what? Duty of registering the companies and discharging various functions, right? They are appointed in various states and UT and vested with primary duty of registering company and LP, floated in various states, and means registering the companies are their duty, right? These offices function as a what? Function as a registry of records relating to the company registered with them, which are available for inspection by members of public on payment of prescribed fees. Then is RD. RD are who? They are in charge of respective region. Each region comprising of number of states and UT. They supervise the working of the officers of the ROC and liquidators working in the region. So they will supervise their work. Okay. They maintain liaison with respective state governments and central government in matters relating to administration of the Companies Act, and this. Certain powers of central government have been delegated to RT. Official liquidator appointed as per 359 section. So far it relates to winding up the company. Central government may appoint official liquidators. These appointed as a whole-time officers of central government, salary and other allowances of the official liquidators, they shall be paid by central government. Next is serious fraud investigation office. The government, in the backdrop of the major following a non-banking financial institution, they have formed this multidisciplinary organization to investigate the corporate frauds. It will come to them. It is expected to be multidisciplinary organization consisting of experts in field of forensic auditing, IT investigation, company law, capital market, taxation, and protecting and prosecuting what? The white collar crimes, frauds. NAFRA. NAFRA 132 section, under 132 it comes. Duties of NAFRA are to recommend what? Accounting. They will recommend the accounting and auditing policies to be adopted by companies for approval of central. They will monitor, they will enforce compliance with accounting standards. They will oversee the quality of services of the professions associated with ensuring compliance, perform such other duties as may be necessary. So these are the duties. They will recommend the policies, which are very important. NCLT. The setting up of NCLT are the two parts to move a regime of faster resolution of what? Corporate dispute. Whatever disputes will come relating to corporates, it will come to NCLT. Thus, for improving the ease of doing business in India. So they have been formed to improve and easing all judicial matters relating to company law under one field. So, you clear? ROC, RD official liquidator, SFI serious fraud investigation office, NAFRA, NCLT. This is MCA. This is how our MCA looks like, and here you can find my application my work space you can find view company master data, where you can view any company records. Then is with the advent of IT in all sectors today, government across the globe, including Government of India, taking major initiative to integrate IT in all processes. Electronical governance, like e-governance, and application of IT of the government functioning in order to bring a smart governance. I told you, na, e-governance is highly complex, requiring hardware. This is same repetition. Important aspects of MCA 21 is organization of ROC office under MCA. The ROC office, working from its present address, has virtually become a back office of the ministry, since the number of companies found it difficult to switch over to e-filing, right? So, facilitation centers known as PFOs were set up throughout the country to provide the what? E-filing. So, physical offices are also maintained for e-filing. Now is front and back office. Front and back office is what? Front office is, which is front, virtual front office and registrar's front office, two types. Virtual front office is one of the various channels available to stakeholders to enable them to do statutory filing across the country. It merely represents a computer facility for filing a digitally signed e-form processing the MCA portal. This is virtual front office. Next is registrar front office. To facilitate a change over from physical document to digital, the ministry started offices, that is registrar front. It is one of the channels available to enable them to do the statutory filing across the country. They are managed and operated by operator RFO, has all facilities which are required for online filing, like trained manpower. For online filing, you can physically meet this registrar front office. Then is back office. Back office represents the office of ROC, RD, headquarters, and takes care of internal processing of the forms, such as per the MCA guidelines. The e-forms are routed dynamically to the concern for processing depending upon assigned role. All e-forms, so electronical forms are there, along with attachments are stored in the electronical depository, which the staff of MCA can view depending upon access rights. Then is certified filing center. In order to provide the companies to do e-filing, then is professional institutes like your institute, ICSI, their regional councils, chapters are there, were authorized to create and set up a required facility for facilitating the e-filing process. The certifying filing centers, the setup, the professionals are over and above the registrar front office setting up by the registry, while the services available from the facility set up by the ministry are without the charges of the these entail the payment of service charge. So these are the service charge. This is back office, front office, virtual front office are there, registrar front office are there, right? Then is what are the benefits of MCA? Basically, the benefits are simply like effective due diligence would be there, effective service by professionals, environment friendly, speed, transparency, and what? Efficiency, mutually beneficial system will be there, and better supervision, monitoring of compliance would be there, and effective use of the database. Now you can just by scrolling e-filing you don't have to physically go and visit the physical offices for filing these forms. It can be done online as well. What will be the MCA services? Register DSC, apply for DIN, index of the charges, view master data. I told you how to view LLP services, e-filing, complaints you can register, investor track you can SRN, you can do everything, you can do by online e-filing, right? So just go through, give it a glance once, and this is not very important. Give it a glance. How can you log in? One day I will tell you how to log in MC and what all things you can do in MC, right? So what are they? Oh, that's all. This concludes our chapter. Okay. So lesson wound up. Simple major developments in company law. How was it? Doctrine of constructive. This ultra vires. Read this. This also marks this fraudulent glossary. You can see what is doctrine of inter vires, constructive notice, e-form, cooperation. Then then this concludes your chapter. Basically, you can just mark these main things, and then I'll tell you this main this front office, back office, and everything. Even you can mark this glossaries also, important glossaries. So come to these questions. I would like to tell you this. Please do this MCQ question, and all these are important. Discuss e-governance. Accept this. Kindly go through these questions, and you will find the answers in the module itself. Yeah. So this completes our very first chapter. Just a second. Introduction to company law. Where is the index? So this completes your first chapter. Tomorrow we will begin with the legal state and type of registered companies. Let us see how long this chapter is. This is not that much important. Sorry. Important case law you should only study, okay? Okay, this definitions that you have read now, the basic definitions that you have read in this first chapter, the same definitions, explanations will come into the second chapter. So I would like you to please give it a glance, the definitions that is given in the first chapter, so that when we will come to second chapter in the second class, you should know the gist of the chapters, okay? I would like to tell you the series. This first we have done, second, third, fourth, 5, charges we can complete 6, 7, then 8th, 9th, 10th, 11th, 12th, 13th, 14th, 15, 15, 16, 17, 18. Fine. This will be the series of our classes. This is how we will complete. And what is the strategy to crack the exams? I have told you multiple times. Just read the concept, understand the concept, important words, phrases, kindly mark these phrases, and then compile everything. And one scanner is available in the market. Past year questions would be there. Scanner is Suchita. This scanner is very good for your CS examinations. So kindly buy this scanner when as soon as it is available, which will cover the latest previous year question paper. For example, if you are giving your paper in your June attempt, or maybe you are giving your paper in your December attempt, please make sure that that scanner has June attempt questions and answers. And if you are giving in June attempt, please make sure the scanner you are buying have the question and answers for the December attempt, so that you come to know what all questions, how the questions are framed, and how, what all facts of the case, how the situational questions come across. Yeah, this is how you can do it. Meantime, I'll give you just 5 minutes of the time if you have just not marked in the important phrases. First of all, these case laws are very important for you to mark. Please mark down this. Very important case law is Connor's brothers. Vodafone case, please read, and for next class we have to read. Workmen employed in Associated Rubber Industries Limited Bhavnagar versus Associated Industries Limited Bhavnagar and another. It is very important case law. Mean and include, it can simply 2 marks question can come from here. In this chapter, and also please write down one more thing, important concepts. In your index also, index only you can write down. Important, 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 important for exams, 5 marks, and case studies based. Okay, this you can write down 2 marks, and only conceptual questions will come. Conceptual matlab theory questions. I'll not go beyond this. Means theory questions. Hardly 2 marks. 2 marks or maximum 3 marks. So you need not waste time on these questions. And for them also, mark conceptual questions, means only theory questions will come. Okay, so need not waste time on this. That's why you can write down in your index only about this. So for each and every chapter, I would like to tell you, I would make a proper habit of bifurcating what are the conceptual questions, what are the theoretical, means like theoretical questions, and what are the case based questions, and which all are the case based questions, which are for the case based question, which all company law, case laws you can write down. This is also very very important. For each and every chapter in your index only, make it a habit to write it, because it will help you to crack the examination. Okay, and write down these concepts as very important. Okay, I'm just rubbing this, hope everyone has written. Very important for case based questions. Okay, this is how you have to write it. Okay, and anywhere near here I will give you one gist of how the facts facts based questions are answered. First, facts of case. Second, interpretation of law. Facts, how the facts are related to interpretation. What section that you have wrote, how the facts are related to interpretation. And fourth is conclusion, probably in 2 to 3 lines. This is how you will write fact based questions. You can just write it down in your module only. Conclusion can only be of 2 or 3 lines, not more than 2 or 3 lines. Okay, don't try to conclude the answers. Whatever you have written, you are writing the stories again and again in the conclusion. That will definitely, it will not give you marks. Conclusion, simply 2 or 3 lines, that's all. Conclude, right? So this is how you have to write. So I will have to. So hope you have enjoyed the lecture, students. See you in the next lecture. Meantime, please, I would like to tell you, whenever you come to next class, make sure that you read and give glance to each and every concept that we have covered and conclude it in your mind before reaching the next class. Because see, all the chapters in company law, in especially in CS course, it is very much related. You cannot skip the previous class. First, read and understand the concepts which are taught in the previous class, then come to the second class. And because see, the second class, same as that, I will tell you, second class concept is relating to, I have told you this types of the companies: private company, public company, dormant company or listed company. Their concept is elaborated in the second class. So before reaching to the second class, make sure that you read the proper concept which we are taught. Because see, basic definitions we have done it in first class only. In this class we have read about what is dormant company, what is private company, what is public company. Apart from this, many other definitions are there, right? So whatever definitions, if you are clear with the definitions, you will learn. Even if you will enjoy the next class for the elaborated concepts of public company. And most important are that definitions that are covered, because definitions will only help you in that conceptual courses questions which can probably come for 2 marks or 3 marks. So 2 marks and 3 marks, if you are very much confident about the concept, you are able to crack it. And also for conceptual courses also, I would like to tell you one thing, that do not make it a practice to write it in a paragraph. Make sure that you write it in the bullets, or you write it at the point wise, so that the examiner come to know that yeah, this person, no, this is very presentable. The presentation are really very count in these examinations. Again and again, I am telling you one thing in every lectures of mine, when what you will listen, that presentation counts. You should know how to present. Suppose this particular fact based questions, now fact based questions come, people will read the what is asked in this particular questions. They will read this particular situation is asked, and now they will write it in a paragraph. That person will definitely will not get full marks, or even I don't think so that the person will get even a half marks for this. Why? Because examiners see your presentation. You should be presentable, because you're entering into a very professional field of yours, and you should not cram the concept. Rather, you should know how to understand, and if you have understood, you should know how to present it. So this is that's why I tell you in every lecture, each and everything counts. For example, the facts of the case, if you have read that facts of the case question. You should know how to the concept. You should know how to present. Suppose facts of the case, so and so directors have been involved in this particular case. You will write facts of the case. A point B limited director sue for so and so. C, this happened. D, what has all in this particular question has been asked by you. Write the facts, then after the interpretation, which section you have quoted, section this is state, write it on 1 or 3 lines, and then how this fact are related to the section that you have quoted. Justify by giving a particular example, and then make it a conclusion. Hardly 2 or 3 lines will be covered. This is how you have to present it. But yeah, you will come to know post you are listening to my lectures how good presentation can be there. Thank you so much, students. See you in the next lecture.